2000. He got Master of Law from University of Diponegoro at 2003, and he got PhD from Queensland University of Technology, Australia at 2018. He is also a member of Asian Criminology Society and Mahupiki since 2019. He is an expert at criminal law and criminology, and it can be recognized through his publications. First publication, for example, the challenge of implementing the radicalization program for terrorist prisoner in International Journal of Criminal Justice Science in 2020. His second publication, a literature review on Indonesian deradicalization program for terrorist prisoners in Mimbar Hukum Journal 2017, and his third publication is regulation of death sentence policy in RUU KUHP Jurnal Katapatika 2007. So today he will present about the new criminal code of Indonesia, a part of criminal law reform. Very relating topic actually, because Pak Gede is one of the drafter of RUU KUHP. Please clear applause for him. So without any further ado, I will give the time and stage to Pak Gede. The time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. Shalom, Om Swastiastu, Salam Rahayu for all of us. This afternoon is a very lovely day for all of us because today we're going to have the second plenary session for the International Conference on Law and Society held by the Faculty of Law, University of. I would like to tell you about my story, which is about last month probably. I had a conversation with senior lecturer, some of senior lecturer here in the Faculty of Law. We had a dinner. We eat satay. Do you know satay, right? We had a wonderful dinner talking about Indonesian new penal code instead of having dinner. So they asked me, Agde, you are the one of the drafter. I questioned a lot about the content and the substance of the draft. Yes, please ask me, which one do you want to discuss? And we discussed and talking a lot about some aspect of the new penal code of the Republic of Indonesia. And I found that some of junior lecturer at the Faculty of Law still questioning about the importance of the new criminal code for the Indonesian government and for the Indonesian people. Why do I tell this to all of you? Because my presentation today is going to talk about why Indonesian government, why we should have the new criminal code in Indonesia. The operator, can you please start the PowerPoint, please? The title is quite general and simple. I changed slightly the title of my presentations. The new criminal code of Indonesia, a part of criminal law reform. But as I said previously, I wanna show to all of you that's why the Indonesian government, why we should have the new penal code in Indonesia. So that's the goal of my presentation today. Next slide, please. Next slide, please. Yes, please. Okay. I want to start by saying that the history should be learned about the long way to have the long way for the Indonesian government to have the new penal code. One of the most important thing that we remembered about the new penal code is the public rejection of the draft of the criminal code. There are many rallies, there are many demonstrations, including uni students say that we don't need this penal code. There are many reasons. There are many reasons for someone who reject the draft of the penal code. For example, when we discuss about death penalty, there are many reasons for someone who said that I don't want to Indonesian new penal code regulate death penalty. We should abolish the death penalty from the new penal code. That's the first example. The second example, in the new penal code, is also regulate about sex without marriage, which is punishable now. So someone said this is about a private matter. So the nation should not regulate about this kind of private matter, etc. So many reasons for someone who disagree with the content of the new draft of the penal code at the moment. And also in the past. As I said previously, my story when I had a conversation with a lecturer here at the Faculty of Law, someone said that I still questioning about the content, the substance of the new penal code of the Republic of Indonesia. That's okay. That should be okay. But once again, we should look at the history and what happened in the past, and now we're moving forward to look at the future. What's going to be happen in the future when the Indonesian government introduced the new penal code in Indonesia. So this is the public rejection of the draft, the criminal code that's happened in 2019 and also, 2020, 21. There are many demonstration rallies on the road saying that we don't need this kind of penal code in Indonesia. Next. Then why is the new criminal code needed? This is the question that we have to be addressed. In the classroom, I discussed this with my students in the Master of Law program, and also for the bachelor students, I discussed this issue with my student. Why is the new criminal code is needed? There are four major reasons that we have to understand. So we need to open our perspective, and then we have to realize at the end that yes, we need this new penal code. The first reason is political reasons. We need the new penal code because of the political reason. It means that very simple, quite simple, because political reasons means that as an independent country, as an independent nation, the Indonesian government, Indonesia should be able to make their own laws. Maybe some of you already understand that we are colonized by the Dutch government for 350 years. Because of the colonization as well, we adopt the Dutch law. So we apply in Indonesia at the beginning of the independence mostly the Dutch law, including the Dutch penal code. So uh, according to the political reasons, once again, as an independent country, as an independent nation, the Indonesian government must be able to make their own laws. And fortunately, we can make it one. We can make it one this year. At the beginning of this year, we issued the new penal code through laws number 1, 2023. So quite simple and easy to understand in our mind. 1, 2, 3. Laws number 1, 2023 about the Indonesian penal code. And the second reason is sociological reason. What does it mean, sociological reasons? It's pretty easy to understand as well. Sociological reason means that the laws that produced by even though local government or a government, national government, so it must reflect the sociological or situation in the society itself. As adoption of Dutch penal code, the existing of Indonesian penal code, which is adopted by the government from the Dutch penal code, it means that the value in the penal code, in the existing penal code, reflects the Dutch uh, culture and the Dutch people. This is the consequence of when law is making in one area or a geographical area. So that's the consequence of the laws. So we need to understand that uh, the existing penal code. Why I said the existing penal code? Because we now still applies the Dutch penal code until in 2026. So it reflects once again the Dutch people within the penal code. So that's why we need to create ourselves. I mean the law who created by the Indonesian, made by the Indonesian, made in Indonesia and made by Indonesian. So that's the point. So it will reflect the value for the Indonesian people, the law. And the third reason is practical reasons. Maybe some of us didn't realize that the penal code doesn't have formal or official translation from the government. So until now, we don't have any official translation for the Indonesian Penal Code. Pretty sad. So the translation provided by scholars, criminal law scholars, for example, Professor Mulyatno, Professor Andiamsah, they translated the Dutch Penal Code. We call it Wetboek van Strafrecht. We will see in the next slide. So there is no official translation available. This is a big problem actually for the law enforcement officers because they probably use one translation which is different from another law enforcement scholars. So maybe it will be injustice when the law is applied for the legal cases, criminal legal cases. So that's the practical reason. And the last one is adaptive reason. What does it mean, adaptive reason? It means that the criminal code must be able to adapt with the international standards, international development, or international convention on crime and justice. We understand that in the penal code, in the existing penal code, we don't have, for example, cybercrime. We don't have for example, terrorism in the existing penal code, because the penal code, the Dutch penal code, was made in 1881 in Netherlands, around more than 100 years. So it makes sense. The content of the existing penal code doesn't adapt with the international development, international convention on crime and justice. So that's why Professor Muladi said we should have a new penal code in Indonesia. So that is the last reason. Next slide. This is about a brief history of the new criminal code of Indonesia. As I mentioned previously, the criminal code itself was made by the Dutch and applied in Indonesia because of the colonization, and then adopted into national law through Law Number 1, 1946, concerning Peraturan Hukum Pidana. So that the formal legal framework, how the Dutch Penal Code then adopted into the national law through Law Number 1 of 1946. And then in 1963, the first national law seminar was held. In the past, national seminar is quite a big seminar. And then during the seminar, discussion happened within criminal law scholars, and then resulted in various resolutions, including the need of new penal code for the Indonesia. So one of the most important recommendation from the national seminar was held in Semarang in 1963, stated that the Indonesian government need to make, penal code. So the existing penal code should be replaced by the new one, which is made by the Indonesian people and also based on Indonesian values. So that's the point. We can say then this is the first time for the Indonesian government stated that we have a commitment to create or to make ourselves, laws, which is penal code. So if we count it, it takes maybe nearly 60 years to have the new penal code, and then finally, on the 2nd of January, in the beginning of this year, so the new criminal code of Indonesia is issued. Finally. However, it will become into force 3 years later after the issuing the laws. So it is not directly, applied by the law enforcement officers. It will be applied on the 2nd of January 2026. So 3 years later after the government issuing the laws. So this is a brief history of the new criminal code of Indonesia. Next slide, please. The structure. Now we try to compare the structure between penal code that's made between, and then the new penal code, Indonesian made, we can say that, Indonesian made, where penal code, or we call it Wet Book van Strafrecht, consists of 3 books. Book 1 about general rules, Book 2 about felonies or kejahatan in Indonesian, and Book 3 about misdemeanor or pelanggaran in bahasa. And consists 569 articles. That is the existing penal code. Why I said existing? Once again, because we still use this penal code until until today and until on the 2nd of January 2026. So when 2026, we are going to have new penal code applied by will be applied by the law enforcement officers that consists of two books. Book one, general rules, and book two, criminal acts. So there is no distinction anymore about felonies and misdemeanor. So it only stated for book two, criminal acts. And totally, we have 624 articles in the new penal code. So it's a huge change, not only for the law enforcement officer, but also for the faculty of law in order to deliver the subject of criminal law for law students. It's a huge challenge because the credit points only 3 credit points, but the subjects, as you can see, 624 articles that must be finished in one semester. This kind of challenge for the law faculty in order to delivering the knowledge, delivering the information, delivering the article, the norm, including in the new penal code. So this is the structure if we compare between the old one and the new one. Next slide, please. Now we are going to talk about the correlation as the title of my presentation. Why do criminal code is part of criminal law reform in Indonesia? This is another reason that's why we need a new penal code. As you can see from the diagram over there, so criminal code is part of criminal law reform, substantive criminal law reform. So it was only one part. Another part is about criminal procedure and also the execution. This kind of, theoretically perspective about the correlation between criminal law reform and the new criminal code. So when we are talking about criminal procedure reform, we should have new criminal procedure code, or we call it KUHAP, And then when we are talking about execution reform, we need to have a new correctional law, or we call it in bahasa Undang-Undang Pemasyarakatan. So those of reform, we can then say that was part of criminal law reform. So that's why the new criminal code, or KUHP, is needed by the Indonesian government in order to state it that Indonesia now are moving to criminal law reform. For example, in the existing penal code, the major reason to punish someone based on, the principle of retaliation or retributive, only to, send someone to the jail, give, a very hard punishment to someone. This is an old perspective of criminal law. So we need a new one, the new perspective. What is that? We need to put, the offender not as an object, but as a human being. So they are also need to be rehabilitated. So that's why the perspective of the new penal code is not just only to punish, retaliation or retributive, but also how to rehabilitate, how to restorative. Now we have a theory, we call it restorative justice. It also one of the content in the new penal code. So we need it. And then we can say, when we put in the new penal code, we already, do something like scholars said, a criminal law reform in Indonesia. This is only the small part of the criminal law reform, because in the larger part, in the larger perspective, we can say is not just about this, but also, structure reform, how to reform the law enforcement officer, the police, the prosecutors, and also uh, the justice itself, how to reform the structure of the law, and how to reform the culture. Like Friedman said, the legal culture is also, part of the larger criminal law reform. What we see here is only a part of substantive criminal law reform, which is focused on the substance of the law. Next. I think we are now moving to the conclusion. So it's a bit easy for me to deliver this presentation, because I want to say in general, if you want to discuss a specific thing, we can discuss later in the QA session. When we reach the conclusion, there are 3 points that I have to, and I need to mention to all of you. The first one is about the condition of multicultural and multi-ethnic country in Indonesia make it difficult for the government and legislators to accommodate these various specialties and uniqueness to reach a national agreement. This is very difficult. And the second one, rejecting the new penal code due to a few disagreements regarding some of the articles in the code is not an appropriate reason. For example, I want to ask you, do you agree with living together without marriage? Do you agree with that? Maybe some of you say no, some of you say yes. So it is not possible, to reach a national agreement according to one issue. So that is why, because of 1 and 2 maybe point, we cannot reach agreement, and then it is not wise to say we don't need this penal code. For example, once again, I want to show you when Western people complaining about the new penal code about sex outside marriage. Do you agree with that? Yeah, some say no, some say yes. It is never-ending debate and never-ending discussion. So it is not wise to say that, no, we don't need this new penal code because I disagree with, when living together without marriage will be punished. It is not wise. Because it is not wise to say that we don't have to, reform the penal code. So that's why, once again, the third one, I want to say the third one, the new criminal code of Indonesia is needed, and it is a part of criminal law reform. Even though maybe some of you still have a question about the content of the penal code, the new penal code, maybe one article you questioning about it, that should be fine. And I do agree with the Ministry of Law and Human Rights. If you have disagreement with 1 or 2 articles within the new penal code, you can do what you can do. I want to ask you what you can do. What you can do if you disagree with 1 or 2 articles within the new penal code. Judicial review. It's quite simple because it's never-ending discussion. If you still disagree with 1 or 2 articles, please, you can do judicial review to the Constitutional Court of the Republic of Indonesia. I think that's all my presentation today. I hope you have a question, then we can have a conversation, discussion. So I want to make it clear once again that we need the new penal code because of this is part of criminal law reform in Indonesia. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi
Om
wabarakatuh. This
Santi
is
Santi Om.
pause to Pak Gede. Thank you for the insightful presentation today about the new criminal code of Indonesia. Thank you, Pak Gede. And we are very lucky because we have explanation from the drafter directly. Okay. So I want to summarize this explanation, but if you all have a question to Pak Gede, please hold on because I will give a chance in the end of this plenary session. Okay. So next we will move to our second speaker, Dr. Jane. Before we will move to Jane, I will read her CV, curriculum vitae. So, Jane Alstron, PhD. She is lecturer, researcher, and also project officer. Currently at the School of Humanity, Arts, and Social Science, University of New England, Australia. She's occupied as a lecturer and unit coordinator of Indonesian program linguistic Asian language governor since 2018 until present. And she was also a research assistant in corpus linguistic and research assistant of Indonesian program of University of Queensland in 2018. She was also senior project officer on Queensland's Department of Education since 2008 until 2013. So she is an expert on linguistic, international education, policy development, and cross-culture consulting. So how about her education history? So Jane has got a bachelor degree. She actually got two bachelor degree. First, Bachelor of Arts in Asian and International Studies, and second, she got a Bachelor of Arts in Language and Applied Linguistics from Griffith University at 2005. And she also got first class honors Bachelor of Arts in Humanities and Asian Language in Curtin University at 2013 and got a PhD at University of Queensland, Australia at 2019. She has a lot of publications that some of them about Indonesian studies. Awesome. First, conveying emotion in the poetry of Norman Erickson Pasaribu at Alitra Review Journal in 2020. Second, Women, Media, and Power by Routledge 2021. And the third, the recently article is Online Media and the Politics of the Jokowi Era in Asian Studies Review in 2023. So without any further ado, I will give a chance to James, but however, because there was a sudden and urgent event, she cannot attending directly to this plenary session, to this conference, yeah. But we still have her insightful presentation through video Zoom. So without any further ado, please to committee to display the video from Jane.
Hello, everyone. Thank you so much to the lovely people at UNED. I'm glad that I can participate in your conference, although I cannot physically be with you. But it's my pleasure to share with you my perspective as a critical discourse analysis scholar on the role of language in achieving good governance. So my name is Jane Allstrand, and I have a PhD in critical discourse analysis, and particularly the Indonesian language and its use in the media. But today I'm going to be talking more specifically about good governance, or the language of institutions and how it can be used to achieve democratic outcomes. So critical discourse analysis, I'm sure you're all aware of this term, this discipline, this approach, but perhaps not fully understanding what it's all about. So let me explain a little bit. Basically, I like to think of CDA, or critical discourse analyst, as the suspicious linguist. So they like to look for the hidden meaning, not so obvious meaning on the surface of the language that we use. And the reason that they are so interested in the underlying meaning is that the language we use, or discourse in context, is a form of social action, and it has social causes and consequences. So we aim through in-depth and systematic analysis to uncover or pull apart, deconstruct language and reveal the underlying ideology and structures of power that are embedded and reproduced in language. And through the use of language, it can lead to discrimination or uphold discrimination and social inequality. And it can also be a source of good. It can be a way of achieving inclusion and social equality. So we know that being discriminatory directly is socially and politically unacceptable. People would revolt. They'd say, wait a second, I don't like what you're saying, because they can clearly tell that you're being racist, sexist, or whatever. So often these kind of more racist or sexist, other discriminatory ideologies are concealed in language. So that's the role of the CDA specialist, is to find these subtle ways of conveying discrimination or top-down dominance in language. And these more subtle ways are easy to deny. So for example, you start a sentence by saying, I'm not racist, but our country needs to, stop immigration. You can say, well, I just said I'm not racist. So therefore, the next thing that I'm saying is not going to be discriminatory. That's just one very small example. But some of the examples I'm going to talk about today are specifically about good governance. So we're going to hone in on these aspects of language. So before we get into this language, we need to think about what exactly is good governance, because in CDA, we don't take things for granted. We don't take things at face value. We like to define what these words mean. So basically, governance, it's a process of decision-making and the process by which the decisions are implemented or not by government organisations at all levels. And good governance should also include some degree of consultation with the public. Doesn't say how much, but it's basically the way that organisations, institutions run themselves. And so what about the good in good governance? What does that mean? Well, there are many definitions, but in essence, it focuses on justice, inclusion, and equity. In other words, democracy. So fair outcomes for people. So to achieve this, we need to be transparent, clear, open, and accountable. That means take responsibility and clearly allocate responsibility in all of our communication. So that's where the CDA perspective is really useful, because it looks at the way these decisions are communicated, or the process of decision-making is communicated, and deconstructs the language to point out, hey, Here's a point where you're not being transparent. Here's a point where you're not being accountable. So we're going to focus on some of the language that is used in institutions, governments, for example, that can uphold social inequality. So the first one I'd like to draw your attention to is the use of acronyms and abbreviations. So I'm sure every one of us, I'm Australian, and in Australia, our institutions use them as well. I'm sure all of you are familiar with some acronyms in your life. Indonesian is quite famous for having lots of acronyms, but you'll see it often talking about development, for example, like relationship between good governments and sustainable development. You'll see something like SDG. We know that comes from the UN, from the United Nations, but sometimes we take these acronyms for granted. They're very convenient, they're easier to remember than long, multiple syllable words, and sometimes they're kind of fun. They might sound funny to say, but we often don't question what they actually mean. We don't define them. Okay, so it creates some language barriers as well when we use them too much. Sometimes when we see an acronym, because it's just letters and not a word, people may disconnect, disengage, and just accept, okay, whatever you're saying, I'm not going to fight because I'm not engaged. For those of us who understand what these acronyms mean, it can create this sense of solidarity among your colleagues. But while you're building your solidarity, you're excluding others who do not understand what they mean. So in this case, it can lead to disinformation, consent through ambiguity and overexposure. So like I said, people will just accept, they won't fight. As a university lecturer in Australia, I open my university email and I will see official discourse, official emails filled with acronyms. And when I see these acronyms, I think part of my brain just switches off and, oh, here we go, some more boring institutional discourse, whatever, okay, no fighting, where I should be a little bit more aware. And the institution should also be more careful with the overuse of these acronyms. So it can conceal the power as well behind the organisation with an empty meaning acronym. So think of some of those acronyms that you hear or use on a daily basis. Do you know what they stand for? Or do you have to stop and think, oh, actually, what do they mean? How do you feel when you hear or read discourse that includes lots of acronyms? Do you feel the same way as I do? Possibly. So another example might be PNS, Pegawai Negeri Sipil. Yeah. So you say, oh yeah, so I'm a PNS. Saya seorang PNS. Or dia seorang PNS. But when you hear PNS, it's just letters, right? When you hear Pegawai Negeri Sipil, that actually means that you are an employee of the nation. So therefore, there's probably a higher degree of responsibility there, rather than easily describing someone or yourself as a PNS. You kind of avoid or do not acknowledge the level of responsibility and the actual role that that person or yourself is playing. Another common target in institutional discourse among CDA scholars is something called nominalization. So that's a linguistic term, and it basically transforms active verbs and adjectives into nouns. So they're more abstract. They don't have an agent or a doer, well, a pelaku, or an object. Okay, so it's just this intangible process, and it can represent value or goals instead of people, things and actual actions with an impact on something. So in Indonesia, you'll often see it in nouns. Okay, so the famous one since the New Order is pembangunan. Yeah, so pembangunan is from membangun. Yeah, membangun negara, for example, right? So pembangunan, on the other hand, is an ongoing process. It doesn't have a start or an end, doesn't have a doer, an agent. So who is doing pembangunan? We have to say like, kita akan melakukan pembangunan. Okay, we have to put it together in a sentence, but if we say kita harus membangun, it's more active and it needs an object after. You need a target to be specified, and that's part of the rules of grammar between transitive and intransitive. So you'll also see it in some words like peran or kean. Okay, so perkembangan or kesetaraan, so referring to, you know, results, product, the actions or values, concepts like kesetaraan, apalagi ya, kecantikan. Okay, so these represent values, so more intangible. You'll see it in loan words as well, like ASI, ISME, investasi, reformasi, stabilitas. So reformasi, I think reformasi, the term itself, although the idea is good, but the terminology is a little problematic from a CDA perspective because it is this nominalization. It doesn't actually have a space grammatically for tangible action with a tangible goal or result. And plus it's based on a foreign loan word, reform, yeah? So I think, you know, if we avoided nominalization, we could be a lot more specific, a lot more on target with what we want to achieve and who's going to do it, when's it going to happen, what's going to be affected by these actions. Whereas if we talk about reformasi, that's so abstract, you know what I mean? Yeah, but English, you'll see it in all sorts of different suffixes like ION, ENC, ment. Oh, we have too many suffixes. So Indonesia has like a fairly clear package of affixes that can result in nominalization. So I do acknowledge that sometimes we need to use nominalization linguistically, when we've already mentioned what's going to happen, who's going to do it, what the target is, and then in the next sentence we can talk about it more, more abstract way. And also, we don't want to repeat the same things over and over again in too much detail because cognitively our brains won't listen, won't process it. But that said, it's best to minimize it if you want to present a really clear and practical, achievable or doable image or message. Another one is passive agent deletion. Okay, so this is a linguistic term, okay, when we write in passive form, okay, so often the object will be there going first, and then, so this is common in Indonesian, and then the verb, okay, all right, but the doer, the agent, is not there, okay, so it's more active or impactful than nominalization because it can have an object, although not always, but we still don't know who is responsible for doing it. So sometimes you can use this to conceal information strategically when you don't want to be too direct, accusing someone. It can also make the responsibility for an action or activity ambiguous. It could be all of us responsible, or could be none of us. It's easy to remove that responsibility when it's convenient, when we don't have an agent. Sometimes you'll see it combined with a modal, harus, okay? Mesti, okay? It urges action to be taken, okay? But responsibility is ambiguous. Who is actually going to achieve this? So misalnya, for example, permasalahan ini harus diperbaiki. So this problem needs to be fixed. Okay, by whom? So sometimes this is used by lazy or sneaky people who want to avoid actual, accepting, taking responsibility for something. Yes, and like nominalization, sometimes linguistically, we need to use it, okay? So if we already know who's going to be doing it, we've said it in the sentence before, and the next sentence, instead of repeating the same thing again, we can write it in passive form. And it's always interesting to vary your sentences, okay? So, and also sometimes when it doesn't matter, like rumah ini dibangun pada tahun 2001. Okay, this house was built in 2001. Who built it? Doesn't matter. It's not important in this conversation. Okay, but again, like I said, same as nominalization, let's avoid using it too much because we need to be transparent about who is responsible for something. And on a similar note, we have the inclusive we, okay? So including us, we or us, that's good, right? Okay, not always. So often political leaders, like when they're giving a speech, or institutional leaders will use this kita in Indonesian or we or us in English to make it sound like a call for action. Ayo kita lakukan ini. Ayo kita membangun negara. Okay, let's do this. Okay, sounds like everyone's involved. We've got solidarity, right? But at the same time, the allocation of responsibility is not so clear. So the audience, the people listening, are involved as well. So, well, it's my job too, huh? Okay. All right. But the role of the institution isn't exactly clearly stated. So in that way, people just accept it. It manufactures consent. So it's like, okay, we're all in this together, I guess. So not all languages have this explicitly inclusive first person plural, kita, and exclusive first person plural, kami. So Indonesia is really clear. When it's kita, it's everyone. When it's kami, it's us and not you. But so it's easy to identify when they're doing this. But in English, if we use we or us, it's context dependent. But we still know when it's we call it the royal we, when everyone is being roped in, being involved, if they like it or not. Okay, so if the audience is truly involved, or the listener is truly involved, and you're talking about the plan clearly with clear steps and allocation of roles and responsibility, go for it. But if you're just going to use it in a superficial way, I'd say avoid. Okay. So finally, recommendations from a CDA perspective. Well, when we talk about good governance or being democratic, basically, I think some themes came up. Transparency, being clear, being open. Responsibility, being clear about who does what. And being precise, okay? What does this actually mean, okay? If we uphold these goals, then hopefully we can achieve more democratic outcomes. And sometimes when we're speaking, we feel, this is a burden. I have to be careful about everything I say. I can't speak naturally. Well, yeah, I agree. Sometimes we need to relax. But other times, if you pay attention to the way that you're using language, it can actually, if you have democratic goals in mind, you want to achieve equality, justice, fairness, then paying attention to the role of language can help you achieve these goals. So paying attention to agency, okay, who is doing what? Time. When are we expected to do this? When is it going to happen? Who's going to do it? When's it going to happen? And what do these words you're using actually mean? So like reformasi, okay, who's responsible? Okay, what are you going to do? Okay, so probably we need an agent and an object, not an agent. We need agents and objects. We need tangible actions and goals and outcomes. Time, we need a time frame. When is it going to happen? And meaning. What does, for example, reformasi actually mean? Okay, so we need to outline this. So like I said, language can actually help you achieve these democratic good governance outcomes. It can be a useful evaluative tool as well during the development and after the process of implementing a program. Okay, so notice here I've got the process of program development and implementation. Program development and implementation, total nominalizations. I get it, these words are problematic, but hopefully all of what I've said today has kind of compensated for my slip into government talk, institutional talk. So yeah, why not give it a try in your next communication? Try and identify roles and responsibility, who and what they're doing, how the programs will be delivered, when, where, by whom, and also why. Why are we doing this? And in that case, we need to define certain terms so we know what the point is. Okay. And I should mention to conclude, in this digital era where we're all communicating through our phones, you know, we are, okay, and we're reading news and emails, and it's the size of a, you know, a phone screen. People aren't going to hold this in their hands like a book, you know, and read it word by word and tidak dicernahkan ya. Ini langsung ditelan aja ya. So that's the difference. I think we need to be even more careful with our language use and more clear with language use in this digital era because of how fast and how, you know, short our engagement is. So the language we use needs to be what I'd say good quality. And by good quality, I mean transparent, clear allocation of responsibility or agency, being precise with the meaning. And hopefully through that we can maintain our democratic goals. Thank you very much. And I hope to see you in the future in person.
Okay, thank you, Jane. Please give applause, and we hope that next year we will meet with Jane directly. Okay, the good governance and the role of language. It is very a clear and interesting topic, I think, because you know, they explained about good governance in different perspective, different view, with linguistic perspective, and you know, to explain what is a good and what is the governance. It is so important, I think, for all of us. Yeah. And because Jen is not here, for anyone that have a question for Jane, we will provide. You can write your question to Jane in the paper. So I think the committee can provide a paper for the questioner. Yeah. if you want to ask to Jane. And don't forget to mention your name, email, and your question. And I think Jane will answer your question by email. Yeah. So don't forget to mention your email at this paper. Okay. So next, I will open the Q&A session. But before we have a limited time, I think I just open one session for Q&A. So I will invite for all participants here to to give a question for Pak Gede. Yeah, and don't forget to mention your name and affiliation, and also your question. So we have three. Oh, sir, Miss MC. Okay. Okay. 1, 2, 3, 4. Okay. So for the first chance, I will give to Mas Aril, ya.
Thank you for the opportunity given by the lovely moderator. My name is Ariel Lantono, and I'm from Master of Law, University of Jember. Uh, my question is to Mr. Gede, Mr. Dr. Gede. Correlate to this conference theme, how's the new penal code cater the democratic value of the democratic country, not limiting the democratic itself? Because, as we know, there is some article about a punishment about the insulting president of the state itself. The article of 218, for example, it's the first time for this article to be drafted in penal code such as in Indonesia itself. And the question number two is how to tackle the public rejection problem uh, from your explanation, from your first explanation about the problem of public rejection in the new penal code itself. In the socialization aspect, how the KUHP team uh, socialize to middle or lower class society, uh, and then the socialization part of the middle or the lower part of society itself regarding the issues about the penal code itself. Thank you. Time.
Okay, thank you, Mas Aril. So we have two questions here. So next, the ladies.
You. Quoting from Mr. Ariel, thank you for the opportunity, my lovely moderators. Okay, my question is for Mr. Gede. The latest criminal penal code is considered as reflection of Indonesian society. That means it is issued to adapt in sociological basis. But why one of the problems that have been lingered for a long time, namely LGBT, still not regulated or even considered to be regulated as part of crimes, as it is something that have been condemned in our country morally and religiously. Are human rights really act as protective wall for LGBT people in Indonesia, as it is stated by Mahfud MD, quoting our legislative parliament? What do you think about this? And how about our future projection of laws surrounding this topic? Are we ready to accept this community in our country?
Thank you. Awesome question, I think. Okay, the third questioner. Okay, also ladies.
I'll check. Uh, Thank you very much for the time that have been given to me. First of all, I'm Zainuratna Safitri. I have a question for Pak Gede. Actually, thank you very much for your explanations, especially for the story of penal code, Indonesian penal code, Pak Gede. Well, in this nice opportunity, I have a questions, especially about is there any specific about penal policy in order to make on how actually Indonesian penal code can be applied, especially for the law enforcement. Would please give us more explanation about that? Thank you very much.
So the last one is MC. MC. Or maybe I will give the presentation. Miss MC.
Okay, thank you for the opportunity. And also thank you for Pak Gede for the explanation itself. My, my question? Some argue that the new criminal code tends to give greater priority to human rights, such as lighter criminal punishment from minimum 5 years than before, which impose minimum punishment of 10 years. But however, the new criminal code still impose the death penalty. So my questions are, what are the main consideration and reasons for the use of the death penalty in the new criminal code? And what is the main reason someone can take another's life based on the new criminal code? That's all. Thank you very much.
Thank you. And I think I will give one more chance to the participant. Mas yang belakang. Yeah. You can use in English. You can deliver question in English or bahasa. It's okay.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi.
Mister, I apologize. My bahasa that's very difficult for
You can, yeah, you
yeah,
can speak in bahasa.
language. What this is my question. What do the new code in Indonesian will influence the power of the law itself? Because as far as I know, even though a new code has been held in Indonesian, if the human resource of law enforcement officers are not sufficient, it will be difficult for this to happen. Atau saya bacakan bahasa saya aja, Pak.
Yes, yes, yes.
Mohon
Just
maaf
speak
ya.
in bahasa Indonesia. Pakai bahasa Indonesia saja. That's
Iya.
okay. Iya. Saya nanti juga reply-nya pakai bahasa Indonesia. Silakan pakai bahasa Indonesia aja.
Permisi, J. Bahasa Inggris saya memang agak-agak, Bapak. Mohon maaf. Jadi yang saya tanyakan itu adalah apakah sangat berpengaruh tentang pengadilan baru yang dikatakan Bapak tadi di Indonesia, tentang kekuatan hukum itu sendiri. Karena setahu saya Bapak J, walaupun pengadilan baru diadakan J di Indonesia, tetapi ketika sumber daya manusia untuk para aparat penegak hukum tidak memenuhi syarat, atau mungkin kita bisa sebut dengan penurunan integritas bagi aparat penegak hukum, maka akan susah juga terwujud untuk tentang pengadilan baru atau hukum yang lebih bisa memberikan keadilan bagi seluruh masyarakat atau rakyat di Indonesia. Nah, begitu Bapak pertanyaan saya, Cik.
Okay, thank you for all questioner, and we already have a lot of question here, I think. So without any further, please, Pak Gede, to answer all the question.
Thank you for the questions. Sometimes I get it, sometimes I lose it. What does it mean? So, to make it easy, can I speak in Bahasa Indonesia for all of you? To make it easy, okay? Okay, I want to start from the last question. What's your name? Okay, from Mas Andy, ya. Oke. Jadi Mas Andy tadi tanya tentang pengadilan dan aparat penegak hukum. Kira-kira begitu ya, Mas Andy? Oke. Tentu pertanyaan ini terlepas dari konteks diskusi kita, tapi tidak apa-apa. Namanya diskusi kan bisa saja melebar ke sana kemari, tidak apa-apa. That's okay, Mas Andy. Oke. Karena memang saya yakin Mas Endi yang juga dengan teman-teman masih S1 semester 1 pasti punya banyak pertanyaan dalam pikiran saudara begitu masuk Fakultas Hukum seolah-olah ini harus diperbaiki, ini rusak dan lain sebagainya. Kira-kira begitu Mas Endi ya. Dan saya memahami ini kalau misalnya kita berbicara pembaruan KUHP, the new penal code, the new penal code itself sebetulnya tidak terkait dengan lembaga penegak hukum. Jadi ada substansi, ada struktur, ada kultur, kan begitu. Yang Mas Endi tanyakan tadi adalah pada strukturnya. Nah, tentu persoalan ini persoalan yang memang perlu mendapatkan perhatian untuk dibahas lebih lanjut, tapi tidak dalam forum pembaruan KUHP atau KUHP baru atau New Penal Code, begitu. Karena New Penal Code itu concernnya hanya pada perumusan perbuatan pidana apa yang akan dihukum, sanksinya apa, kemudian bagaimana si pelakunya itu mempertanggungjawabkan perbuatannya di situ. Ini yang disebut dengan, kalau teman-teman S1 masih ingat semester 3, semester 5 mungkin ya, hukum pidana dalam keadaan diam. Penal code itu sama dengan, identik dengan hukum pidana dalam keadaan diam. Karena dia hanya mengatur perbuatan apa, pertanggungjawabannya seperti apa, sanksinya seperti apa. Nah, kalau yang Mas Endi tanyakan tadi, itu hukum pidana dalam keadaan bergerak. Itu sudah membicarakan bagaimana polisi yang baik, bagaimana jaksa yang baik, bagaimana hakim yang baik, dan seterusnya. Nah ini persoalan lain yang memang concern terbesar ada di situ. Gitu. Katanya Taverna kan, berikan saya satu orang penegak hukum yang baik, maka dengan hukum yang jelek sekalipun, hukum itu akan menjadi baik, kan gitu. Oke, sekarang kita bilang New Penal Code ini adalah sebuah produk yang bisa kita katakan sebagai produk terkini terbaru dalam perkembangan hukum pidana modern, tapi kalau aplikatornya tidak baik dalam tanda kutip, maka hasilnya pasti tidak baik. Sama kayak ketika punya mobil baru, KUHP baru ini anggap saja mobil baru gitu ya, a new car, listrik semua sekarang. Tapi ketika yang mengendarai ini tidak beretika, tidak punya moral, melanggar lalu lintas terus, sama aja nggak ada artinya nih KUHP baru nih. Mobil baru ini nggak ada artinya gitu. Nah oleh karena itu, bagaimana mewujudkan law enforcement dengan etika tinggi, integritas tinggi, ini tantangan tersendiri yang memang perlu dibicarakan di tempat tersendiri, Mas Endi. Kira-kira begitu, Mas. Supaya clear dulu persoalannya seperti apa. Oke, Mas Endi. Kemudian the fourth question dari Salwa, ya. Salwa. I'm going to mix it in English and in bahasa to make it easy for you to understand the point. She asked about the death penalty. Saya mau tanya, dan saya harap ada di pilihan yang yes or no. Teman-teman yang yes akan death penalty, siapa di sini? Coba angkat tangan. Death penalty. Artinya kita harus masih punya pidana mati dan menghukum mati penjahat. Oke, tidak sampai seperempat. Oke, mulai ragu-ragu. Oke, mulai naik. Oke. Salwa tadi tanya, regarding human rights, why the new penal code still have death penalty? Salwa artinya berpikir death penalty itu harusnya nggak ada kalau kita melihat dari perspektif human rights. Kira-kira begitu pertanyaan Salwa. Nah, ini yang kalau kita misalnya tidak ada agreement tentang pidana mati, stuck gitu ya. Anda tadi setuju, Salwa nggak setuju, saya bisa nggak setuju, Bu moderator juga misalnya nggak setuju, ya akhirnya kita nggak jadi punya KUHP baru kan kira-kira begitu. Nah, solusinya bagaimana? Solusinya tim kemudian menempatkan death penalty itu sebagai pidana pengecualian, tidak muncul lagi sebagai pidana pokok. Jadi dalam pasal 10, artikel 10, the existing penal code, the old one itu masih ada pidana mati gitu kan? Pidana mati, penjara, kurungan, denda, tutupan. Artikel 10, the old penal code, the existing one. Tapi the new penal code itu sudah nggak ada lagi dalam artikel 100, artikel 100 Anda cek di situ nggak ada lagi pidana mati. Paling berat itu pidana penjara. Jadi sudah hilang pidana mati itu. Tapi KUHP karena mengakomodir dua kelompok yang berbeda pandangan tentang pidana mati ini menempatkan pidana mati itu sebagai pidana bersyarat. Conditional punishment gitu ya. Syaratnya apa? Syaratnya orang yang dituntut pidana mati kemudian sentence to death penalty, they are not directly to be executed. Jadi dia tidak langsung dieksekusi. Apa yang diberikan oleh the new penal code? They must be sent to the prison first. For 10 years, live in the prison, stay in the prison for 10 years. Jadi hakim itu meskipun dia yakin akan menjatuhkan pidana mati, dia tidak bisa atau tidak diberikan kewenangan oleh KUHP baru untuk langsung, Pak Jaksa tolong dong saya vonis mati, ini dieksekusi terpidana ini. Tidak bisa. KUHP baru, Salwa harus bersyukur karena posisinya justru ke arah untuk menghilangkan pidana mati. Hakim itu wajib hukumnya berdasarkan KUHP baru itu memberikan dulu ruang 10 tahun di penjara. Dia akan dievaluasi ada perubahan apa tidak. Kalau ada perubahan, maka itu akan dirubah dengan pidana seumur hidup. Life sentence, gitu ya. Paling berat seumur hidup dan nanti pun kalau ada progressing bisa berubah. Nah, jadi kalau kita mau mengatakan apakah ini melanggar HAM atau tidak, ini masih debatable, Salwa. Karena dalam perspektif HAM itu ada yang mengatakan memang ini bertentangan dengan HAM, tapi dalam perspektif law enforcement ada yang mengatakan ini bagian dari the rule of law itu sendiri. Jadi masih perdebatan itu ada dan saya yakin nggak akan pernah berakhir perdebatan itu. For my students, tadi yang tanya itu kebanyakan student saya di kelas S2 ilmu hukum, itu sudah mengikuti perkembangan dan pemikiran-pemikiran saya ya dalam perkuliahan maksudnya ya, tadi pertanyaannya oke banget tuh. Itu sudah paham bagaimana positioning human rights dalam penal code dan bagaimana positioning pidana mati, itu bergeser ke arah sudah akan menghapuskan pidana mati, Salwa. Termasuk me myself, I disagree with that penalty. Tetapi sebagai bagian dari tim penyusun KUHP yang tim itu kemudian bersepakat untuk tetap, saya maka harus tunduk pada keputusan tim. Meskipun memang sudah kita sampaikan, diskusikan bahwa posisi ini masih bisa diperdebatkan. Tapi itu adalah konklusi yang paling baik. Yang bisa kita ambil supaya tidak terganjal ini gara-gara satu persoalan ini KUHP baru kita nggak jadi-jadi gitu kan. Oke, kita jadikan, nanti kalau memang you disagree with the articles about the death penalty, please bring to the Constitutional Court. Do judicial review in the Constitutional Court. Okay, itu Salwa about the death penalty. And then the third question, I start from the last question, then move to the fourth question, and now the third question from Mbak Fitri ya. Mbak Fitri, siapa? Mbak Ratna ya? Mbak Fitri yang mana? Oh, saya dengarnya Safitri tadi, makanya saya panggilnya Safitri. Sorry, Mbak Ratna ya? Oke, Mbak Ratna. Ini pertanyaan menarik. Penal policy. Bagaimana posisi KUHP kemudian penal policy, kira-kira begitu ya? Oke. Nah, penal policy atau kebijakan penal, KUHP adalah bagian dari penal policy, kebijakan penal. Jadi mengoperasikan hukum pidana untuk mewujudkan kebijakan-kebijakan sosial atau menegakkan kebijakan-kebijakan sosial menuju tercapainya social welfare, kira-kira begitu ya, penal, bagian dari penal policy. Nah, penal policy ini ada tahapnya gitu. Tahapnya, apa tahapnya penal policy? Itu ada tahap formulasi, ada tahap aplikasi, dan tahap eksekusi. Itu penal policy. Artinya, persoalan-persoalan pelanggaran hukum yang diselesaikan melalui hukum, ini penal policy. KUHP itu ada di dalam bagian dari kebijakan formulasi. Lanjut ke aplikasi, lanjut ke eksekusi, ini bagian dari penal policy ya. Nah, non-penal policy itu apa? Non-penal policy means that legal problems, criminal issues, itu tidak diselesaikan dalam sistem peradilan pidana. Tidak melalui tahap formulasi tadi, aplikasi maupun eksekusi, tapi melalui tahap-tahap yang kita sebut dengan, kalau dalam bidang hukum keperdataan, disebut dengan ADR. Have you heard about ADR? Alternative Dispute Resolutions. Persoalan-persoalan yang tidak diselesaikan dalam kerangka criminal justice system. Nah, ini jadi blur, justru Mbak Ratna dan teman-teman sekalian, ini jadi blur antara penal dan non-penal policy, penal policy dan non-penal policy, when we are talking about restorative justice. Apakah restorative justice itu penal policy or non-penal policy? This is a topic for your thesis, I think. RJ is a part of penal policy or non-penal policy. Kenapa saya katakan sebetulnya ini bisa masuk pada penal policy juga? Karena Kejaksaan Agung, kepolisian hari ini sudah melakukan formalisasi terhadap restoratif justice. Dengan formalisasi restoratif justice artinya RJ itu bagian dari criminal justice system sebetulnya. Tapi tidak selesai sampai di persidangan pengadilan. Dia selesai di tahap penyidikan, dia selesai di tahap penuntutan. Nah, itu Mbak Ratna, saya sudah dijawil-jawil ini sama panitia. Waktunya sudah habis. Gitu ya. Oke, yang the second question, I'm so sorry, I missed it. I didn't get it, your question. Can you please repeat it in bahasa Indonesia to make it easy? Yes. The second question. Sorry, Mas panitia. Sambil menunggu the second question, saya akan respond the first question dari Mas Ariel. Nah, ini semua mahasiswa di Master of Law, mata kuliah politik hukum pidana. Beri aplaus untuk teman-teman S2 ilmu hukum. Ya. Habis ini kayaknya mau makan-makan ini, kayaknya pesta bersama ini anak. Mata kuliah politik hukum pidana. Mas Ariel, oke. Your question is about democracy. We are talking about democracy in the one side, but on another side, the new penal code looks like contradicts with democracy, kira-kira begitu. Nah, ini perlu saya klarifikasi. Kalau ambil contoh yang Mas Ariel tadi katakan, yang sempat menjadi isu, itu adalah persoalan penghinaan terhadap presiden. Kan begitu ya. Itu yang sempat ramai itu. MK pernah memutuskan bahwa istilahnya bisa dipakai ya, penghinaan terhadap presiden begitu ya. Atau insulted gitu ya. Presiden insulted by someone begitu ya. Itu MK mengatakan ini kami cabut pasalnya. MK memutuskan begitu. Tetapi dalam pertimbangannya di pertimbangan MK itu juga dikatakan kalau mau tetap dijadikan delik, jadikan delik aduan. Kami berpikir bahwa presiden itu adalah sebuah ini juga perdebatan ya. Saya ketika di Bengkulu Saya mengatakan bahwa presiden itu simbol negara juga sebetulnya. Dalam sebuah jurnal yang terbit di Amerika dikatakan presidential as a nation symbol gitu ya. Nah, ini terjadi perdebatan juga. Kita ingin menempatkan bahwa posisi seorang presiden itu memang posisi yang harus dihargai. Bukan berarti karena Pak Jokowi presidennya, bukan. Tapi karena siapapun nanti jadi presiden itu harus kita berikan sebuah tempat yang memang ini harus dihormati presidennya, terpilih. Gitu ya. Siapapun nanti presidennya. Jadi KUHP ini akan melindungi dengan catatan itu jadi delik aduan. Ini disagreement-nya juga sama teman-teman. Ada yang tidak setuju dengan pengaturan itu, ada yang masih tadi mengatakan memerlukan itu. Apa yang kami lakukan sebagai drafter, kemudian ini harus dijadikan sebagai delik aduan dengan mengikuti putusan Mahkamah Konstitusi. Jadi presiden, tergantung presidennya ya. Kalau presidennya baperan ya dikit-dikit lapor. Dikit-dikit ke Mabes gitu ya, tergantung presidennya. Jadi kunci itu dari presiden. Kalau dalam terminologi hukum pidana asing ini namanya komplain hanya bisa dilakukan oleh yang bersangkutan. Dalam bahasa Indonesia atau dalam kasana hukum pidana kita namanya delik aduan. Kalau tidak diadukan tidak bisa. Sama dengan domestic violence ya. Domestic violence itu bisa diselesaikan kalau dilaporkan, diadukan oleh partnernya. Tidak boleh tetangga yang melapor. Saya misalnya melihat tetangga saya seorang ibu-ibu wajahnya penyok kiri kanan gitu ya. Dan saya bisa pastikan dipukul oleh suaminya gitu kan. Tapi saya nggak bisa kemudian punya hak untuk mengatakan suaminya itu harus diperiksa Pak Polisi, nggak bisa. Harus si korban sendiri yang melaporkan atau yang merasa jadi korban itu harus melaporkan ke polisi, ini yang dinamakan delik aduan. Jadi kalau presiden itu merasa adalah sebuah insulted gitu ya terhadap dirinya, maka dia diberikan ruang untuk memberikan delik aduan. Kesimpulan saya is not contradict with democracy principle. Ini untuk menjaga marwah kepresidenan. Siapapun presidennya, bukan karena si A, si B, si C, tapi siapapun presidennya kita mau jaga marwahnya di situ. Itu Mas Ariel. Kemudian you ask about the have and you know from social clustering mungkin begitu ya. Anda melihat bagaimana yang punya dan yang tidak. Ini lagi-lagi sama seperti pertanyaan Mas Andy. It is not about the penal code, it is about the implementation of the law. Saya yakin kalau di bahasa Indonesia kan, hukum itu Pak tajam ke bawah, tumpul ke atas, kira-kira begitu ya, korelasi dari pertanyaan Mas Ariel. Dan ini memang challenge-nya. Seperti yang saya setuju dengan yang dikatakan Prof. Mahfud, bahwa penegakan hukum kita hari ini mengalami degradasi dan mengalami banyak PR. Banyak PR-nya di mana? Itu dia tadi, bagaimana justice, law enforcement itu bisa ditegakkan dengan seadil-adilnya. Saya setuju juga dengan Prof. Mahfud, kalau persoalan bangsa ini mau selesai, 50% itu ada di persoalan penegakan hukum. Artinya kalau persoalan penegakan hukum selesai, separuh persoalan bangsa ini selesai. Saya setuju dengan apa yang dikatakan oleh Prof. Mahfud. Nah, ini yang Mas Ariel tanyakan terkait dengan the have dan social clustering tadi. Ini persoalan penegakan hukum yang tentu kita akan melihat bersama nanti bagaimana pemerintah, dan kita kritisi pemerintah kalau tidak bisa menjalankan penegakan hukum dengan baik. That's my response. Saya biasanya agak panjang-panjang ini. Oke, tadi yang kedua ya, gimana? Masih ada kesempatan nggak? Atau enggak nanti kita diskusi aja? Oke, cepat ya.
Ya, intinya saja.
Oke.
Baik, berbicara tadi mengenai KUHP baru, karena kita pakai bahasa Indonesia ya Pak. Berbicara mengenai KUHP baru, belum ada pengaturan mengenai LGBT. Padahal LGBT ini merupakan hal yang sebenarnya sudah dikutuk secara moral dan juga secara agamis di Indonesia. Padahal KUHP baru ini kan diharapkan dibentuk untuk menyesuaikan dengan masyarakat Indonesia yang multikultural dan society-nya itu sendiri. Apakah kemudian perbandingannya dengan HAM? Apakah HAM benar-benar menjadi tembok pelindung bagi kelompok LGBT di Indonesia? Apakah Indonesia memang sudah siap menerima LGBT sebagai kelompok yang kita terima keadaannya, yang kita terima di Indonesia?
Oke, LGBT. Ah, kalau saya jawab secara singkat saja. Dalam perumusan KUHP itu tidak pernah disinggung formulasi LGBT as a crime. Karena kita paham betul kalau ini kemudian kita masukkan, ini akan menjadi sebuah persoalan besar. Karena tadi disagreement-nya itu sangat tajam. Kalau disagreement-nya itu masih bisa dipertemukan, we can fix it. Tapi kalau sudah sangat tajam, maka LGBT itu dari awal draft itu yang saya ketahui itu tidak pernah masuk as a crime di situ. Dan lagi-lagi persoalan ini persoalan yang sebetulnya di luar penal code. Ini kan persoalan bagaimana kita memandang LGBT. Mungkin saudara punya pandangan tertentu, saya juga demikian, semua juga punya pandangan tertentu, depending on apa yang ada di kepala kita. Saya tidak akan merespon lebih jauh dan saya tidak akan berkomentar lebih jauh karena ini forum yang mungkin tidak pas untuk diskusi ini bisa buat juga diskusi tersendiri nanti teman-teman MIH. Intinya bahwa KUHP baru itu tidak mengkriminalisasikan LGBT, bukan berarti kita menyetujui LGBT, bukan juga begitu kan. Ini perlu dipahami dengan baik. Saya kira demikian. I'm so sorry take a bit longer than scheduled. So it is very lively discussion. Thank you very much.
Thank you, Pak Gede. It's very interesting discussion. So we are at the end of this plenary session. Thank you so much for Pak Gede as presenters, and Jane also in Australia, and also all participants here. And I apologize for all inappropriate things along the discussion. I'm Fanny Triayunita. Thank you so much for all participants, and see you on the next year at the fourth conference of on Law and Society 2024. Thank you so much. I will get to the MC.
Thank you for Dr. Jane, Pak Gede, and Bu Feni. Now you may back to your seat. Ladies and gentlemen, next we will have a closing remark from Pak Gede. Before then, since we are now in Jember, a region with rich cultural tradition,
we are proudly present Tari Rupa Kembyang, a traditional East Javanese dance. Ladies and gentlemen, please welcome Jantung Theater.
Wow, wow, wow. That's amazing performance from Jantung Theater, isn't it, Salwa?
Yes, of course it is Anju because they perform traditional dance. What a wonderful culture from East Javanese Indonesia. Once again,
Again, please give applause for Jantung Theater.
thank you everyone. Now we are about to conclude this conference. There will be a closing remark from Pak Gede. And Pak Gede, the stage is yours.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Good afternoon, Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan, salam rahayu untuk kita semua. I would like to tell that, to be honest, the closing remark was prepared by the committee. Thank you to the committee. Ladies and gentlemen, after the first and the second plenaries, panels, and Tari Kembyong, the tari that we have, been together, called Tari Kembyong. Finally, we have reached the end of this conference. I heard that there were lively discussion in most panels. I believe there are lively discussion in every panels, though I didn't join the panels, but I do believe there are lively discussion within the panels. The end of this conference doesn't mean the end of our academic bond. After exchanging of arguments during the panels and plenaries, now you have new colleagues, discussion partner, new friends, or maybe new boyfriend or girlfriend, I don't know. Hopefully you get one here from this conference. That would be beneficial either for your career and academic path. In Indonesian wisdom, we call silaturahmi, as reflected in this pantun prepared by the committee, to be honest. Balonku ada 5. Balon hijau meletus. I don't know why he's talking about balon here. I don't know. Silaturahmi harus dijaga, pinjam dulu 100. Doesn't make sense. But I appreciate that was a pretty good pantun, isn't it? I think that's a good pantun. For those participants who came beyond Jember, after the conference, you may enjoy a Saturday night in our humble city. I really recommend you spend some time visiting our tourist destinations, such as Papuma Beach, Rembangan, Seger Nusantara, and let me remind you to buy some souvenirs like suar-suir, maybe you like it, suar-suir, to your family back home. Yeah, compared to Bali, maybe Bali much better, but Jember to me, myself, is a good city. I like Jember. I love to be part of Jember Regency. Big applause to Jember resident. We are a family. Enjoy the people, enjoy the scenery, enjoy the cuisine, especially satay There are many satay, warung satay here in Jember. Please find one and try to get the best one for satay in Jember. To me, myself, the best satay is here in Jember. I experienced to have satay in Bandung, in Jakarta, in Jogja. But to me, myself, the taste is Jember. To me, satay, the best satay is in Jember. Applause once again to Jember residents. Okay. Thank you for the speakers, moderators, presenters, and all participants for your presence online and offline. Especially to my students as panel moderators, presenters, and part of the committee, you did a great job. Especially to Pak Rian. Big applause to Pak Rian. Please stand up, Pak Rian. Please stand up, Pak Rian. He's the one behind the scene of this conference. Also, on behalf of the committee and the dean, I would like to deliver and apologize if there are any shortcomings, inconvenience during this event. Believe me that we did our best to serve you and welcome you during the conference. A short reminder, as Bufeni explained to all of you, there will be the 4th International Conference on Law on Society next year. So please be aware on the schedule, because we are longing to see you again. I hope you're going to be part of the conference next year, so you can submit your paper as well for the next conference. Just wait the information from the law faculty, maybe in the middle of 2024, you can also join the conference next year in 2024, International Law Conference on Law and Society. So, because I was asking to close this international conference officially by saying Bismillahirrahmanirrahim, I close the 3rd International Conference on Law and Society held by the Faculty of Law, University of Jember officially. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh. Om Santi, Santi, Santi Om. Sampai jumpa tahun 2024. Please, your hand. Okay, I wanna do a slogan for the law faculty. I think you recognize it. Okay. Evaunet. Thank you very much. You are all awesome. Thank you. Thank you.
Thank you for Pak Gede. Now you may back to your seat. Finally, we reached the end of the 3rd International Conference on Law and Society, Situating Constitutionalism and Democracy in Multicultural Society. Thank you for your participation. Please a safe journey back home.
We, Salwa and
Anju,
as your master of ceremonies, wish to see you in the 4th International Conference on Law and Society next year. Sampai jumpa dan terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Shalom, Om Santi, 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 Om Namo Buddhaya, Salam Kebajikan.
diumumkan kepada seluruh panitia conference untuk maju ke depan panggung untuk sesi foto bersama. Sekali lagi diumumkan untuk seluruh panitia conference untuk